Hello there and welcome to the program Know Your Laws, where we talk on matters to do with law, justice and legal affairs, always to educate you, help you and learn new laws that govern you. And tonight we are going to talk a matter that is in the public domain, a matter that has always brought contention in law courts and even in different places, even elders in the villages unable to resolve the matter of succession. That is our topic of discussion tonight with my guest, who is an advocate of the High Court of Kenya, Kevin Doho. Welcome to the program.
Thank you, Chris.
Of course, our discussion tonight will be based on succession, a matter that is not very new to everyone, because in one family or the other, succession is a necessity per se. We just begin at this point. What do we define, or how do we define succession?
Succession is the law of mostly property and dependence of those who have passed on. It is a law that is as old as the world, as since from the days of Cain and Abel till today. So when somebody dies, he leaves behind people, and he leaves behind assets, and also leaves behind liabilities. So the law of succession deals with the aftermath of death.
Now, as we remain now getting to the discussion in regards to the legal aspect of succession, of course, and narrowing down to Kenya now, where we all hail from. The Kenyan law, of course, is very expansive enough in regards to succession. But now to begin our discussion, what does the Kenyan law stipulate in regards to the entire process of succession?
The process of succession usually begins at the moment you get the death certificate from government. Then you proceed to the chief's office. The chief writes a letter listing the person's dependents, and if there are any assets within the jurisdiction of that chief, he'll write about those properties and make sure that they are protected until the court is able to deal with the property of the deceased, in the sense of either settling the person's debts or transferring or transmitting those assets to the deceased person's dependents. So you start there, you go to the chief, they give you that letter, then you come to court and you file various forms that commences the succession process. So the first thing that is usually happening is, if you either were having a will or you do not have a will, what we call testate and intestate succession. Those two processes run concurrently, but they are not together. So either you have left a will, then you'll be going through the process of testate succession, or you did not leave behind a will and you'll be going through the process called intestate succession. What then happens is, if a Kenyan did not have a will, he'll be going through the intestate succession, and you'll file those forms, that letter from the chief, and be able to obtain a grant within 30 days after gazettement. So you go, you apply, then you're first advertised on the Kenya Gazette, then you're able to get your grant after 30 days. This is intestate succession. Now the grant has to be confirmed, in the sense that, yes, there's somebody who has been appointed an administrator of the estate through that grant, but now that administrator is supposed to administer that estate for a minimum of 6 months before he or she applies for confirmation. So confirmation is mostly a way of the court determining who gets what. So you come to court with a proposal of how the property of the deceased is supposed to be divided. From that point, if any person has any objections, they can raise it at that point, either through a protest, or if there is somebody who was appointed an administrator before those 6 months elapse, somebody can come and object through objection proceedings. So after that point is now when the grant is confirmed, if there is no objections or any controversy. So the property now is supposed to move. If it's real property, you use an instrument called an assent, which is taken to the Ministry of Lands if it's land, and the administrator now distributes according to the confirmed grant. Then at least, at a maximum of 6 months later, the administrator comes and files accounts, accounting for how he or she has administered the estate of the deceased and how it has been resolved. Then you're able to have a completed process of intestate succession. So at that point is now when you close the file and everybody moves on with their lives. Now, for the other people who leave behind wills, the process is a bit different. You apply for the grant of probate of the will, where the court actually adopts the will of the deceased as a government document, and the wishes of the deceased are now followed. There are various types of wills. There is a will called an oral will, where somebody, 1 month before they die, they say the way they want their property to be distributed. And there is written wills, where somebody writes down his last wishes and how things will happen, whether the children will be given to which guardian will take, who will take guardianship of the children, and who will get what from that person's will or estate. The benefit of a will is that once the will has been admitted into probate and there are no challenges of that will to revoke it, it's usually easier to be able to distribute properties, especially in a family setup where the people who are married when they both had children out of, before they got married, maybe the woman had a child and the man had a child. So the will be able now to have the property distributed to even people who are not the biological children of that marriage. For intestate succession, you need to prove you're either a child or a dependent. And with the new laws, they have changed a few things in the sense of saying that you need to be a spouse or a child. That is now the new succession amendment laws that have come up. So you look at those two types of succession, testate and intestate. Yeah. So
because the two of them, of course, they're way too different. But of course, the one that the will has been left is one that has a clear path on how the property, or rather the inheritance, should be given out to the dependents. But now, on the intestate one, where there is no will, of course, it will become a contentious matter in regards to who should be now the actual successor of the deceased properties. So my question will be like, who is entitled to claim for succession?
What has been happening is that we used to have various classes of people who could inherit, and they are seriatim. They follow each other. At the top of the list is the spouse and the children, then the father, the mother of the deceased, then the brothers and sisters of the deceased, then any other dependent. The ones who never had to prove dependency were the children and the spouse. Those ones usually got automatically. But for these others, they had to prove dependency according to their classes. So you might find yourself being a brother or a sister to the deceased, and you want to inherit from the assets of the deceased. You have to come to court and prove that during the lifetime of that sister or brother, that you were actually being supported by the deceased sister or brother. The other areas that we have looked at in the sense of the law is not very clear. One of the areas is African customary law, the law of the body of the deceased. We had a famous case of Wamboye Otieno back in the 90s, where in law, or in English law, the one who've inherited, you cannot have a property in the body. But in customary law, especially Luo customary law, the body has its own uses and its own cultural significance. So the court was able to find that the deceased lawyer at that time called Mr. Otieno, his body should have been turned or buried following Luo custom, because the man had lived all his life as a Luo. So those are areas that this law of succession has not yet provided. But with the changing mores of society, now it's the other way around. We find yes, people will be filing those court cases over the body of the deceased, but today it's the other way around. The wife, the spouse, has, according to a recent judgment, has the absolute power and control of how she will or how he wants to bury the deceased. The reason is that in ancient Europe, you used to have bodies, but they belonged to the church because people were presumed to be Christians in that society. So you take the body through that Christian traditional burials, but no one could own a body. Now, beyond that, the other areas that are outside the law, where you have presumption of marriage. So you might find a spouse not able to produce a certificate of marriage to be able now to inherit. But she or he can come out and say, this was my spouse, we lived all our lives together, and everybody in the society took us as husband and wife. So that is a question of fact. That is a question of judicial discretion, whether to allow such a claim or just let it be. So those are the two areas that are outside the law of succession, that as lawyers we have, or as the courts, we have had problems because of the contentions and the fights that we have had for the longest time. The other areas that are outside the succession law in Kenya are those ones which are found under the 10th schedule of the Law of Succession Act. There are 10 counties in this country where the Law of Succession Act does not apply. That is Garissa, Kajiado, there are various, Wajir, there are various things that have been happening, in the sense that people or Kenyans in those counties, Parliament considers them to have their own special African customary law. They will be dealt with according to that area. And this is also flowing from the Judicature Act, which says as far as custom applies to one or both of the litigants or the persons in court, then they shall be bound by African customary law. However, when you come to the new constitution, it says that African customary law cannot overrule or go against the morals or the morality of written law. So you might find certain practices like wife inheritance and other things like that are now frowned upon. As they infringe on a woman's rights to equality under the law. However, the conflict that now is happening in society obviously speaks to the way things are moving from very strong African customs that have controlled various tribes and races in this country to now very loose African customary law, which has very little power in the sense of the modernity that has happened, the industrialization and the various developments that society has gone through. So yes, it will have certain strengths in the sense of informing the way the children will move on with their lives, who gets what, the modalities of the burial ceremonies, things like that. But for right now, we in this world or in this country, in this age, African customary law has gone underground for reasons of the way society is setting itself up. Yeah. And
for that case where there is the common English law, that is the written law, that of course is usually applied in determining succession matters, and then there is the traditional customary laws that again are also used in determining succession in some of the counties, especially to say the Muslim oriented counties, the likes of Garissa, the likes of Mandera. Do we see a contradiction between the traditional laws in determining succession and the common written law when such a matter of contention arises in terms of who and what should be inherited?
For various reasons, the law is not uniform because we still have a special treatment for Muslims under the Waqf Commissioners Act, where when a Muslim dies, they leave behind property for the mosque and for the Muslim Jumia, what they call the Muslim world. So that part of the estate is considered waqf or trust. So those are religious trusts that are enacted and registered and they work, and they have various rules under Sharia law. So you might find, yes, we have the Law of Succession Act, but we have various sensibilities and laws that deal with the special people in the society. Now for African customary, it's not codified, although Eugene Cottrell and some other anthropologists have tried to come up with things we call monographs of a summation of African custom, but they have not yet brought it into a well-organized statutory mechanism of deciding what is African customary law or what is not. What we have in Kenya is, if you are alleging an African custom, you must produce evidence of that custom. Either you bring elders from that community, or you bring religious or anthropological monographs, or learned treatises like the ones for Eugene Cottrell, or other treatises on African custom from either the anthropological school in University of Nairobi or the other people who have been doing ethnography. Then the court will now say and surmise there is a custom that is affecting these people who each looks this and like that and like this. And under the Judicature Act, I am, as a judge, obligated to apply African customary law where it affects one or both of the people who are in court. So as far as succession and marriage and the children's law, those sensibilities that flow from African custom are special and have to be specially proved to the right standard. You just can't come and allege and it flies. You have to achieve proof to a certain standard. Now, for the other side, which is religious law, that is Christian and Hindu, those ones obviously will be dealt with those types of laws and marriage and customs. For example, for the longest time we had the African Christian Marriages Act, which now is a section of the Marriage Act. So you might have various ways of finding religious law affecting Kenyans in this country. Yeah.
And now, as we move on and remaining on that matter to do with traditional and written common laws, in a scenario where one of the parties under the customary determination of succession feels dissatisfied by the decision perhaps made by the traditional community, or rather the determinants of who to succeed or who to benefit from the succession, and moves to court seeking revocation of a determination of succession by the traditional community. Now, does the court upheld what the community decided on the customary laws, or now it has to move in and make determination under the common written law?
What I can say is custom and common law are nearly the same, because common law is the summation of traditional English customs. What used to happen is once, a long time ago, we had the Norman conquest of England in 1066. What happened then is that William the Conqueror came in and conquered the people of Britain. At that time they were having their own laws, their own customs. Now when he had conquered them, he established a feudal system. Now this feudal system had a court system, what we call circuit court, which was now the court of the King's Peace. They used to go around and determine disputes in England, the people who are conquered, according to their own customs. So the common law became refined over 1,000 years. Now we are in 2021. It has been refined based on the customs of the English. Now, when you look at our law, it's the other way around. Now, it's the English who came and conquered various parts of Kenya, or they took over, saying this was empty land with no Africans, and if there are any Africans, they're like animals, or they are not. They don't have the concept of private property. So this land here is crown land, and these are people who we can herd and sell in the way we want. So for us, the summation of our customary law has happened from colonial era up to 1979, when we finally had a law of succession. Now, that law of succession was a negotiated settlement of how to deal with the property of deceased persons in Kenya. So all we can say is, as far as the Law of Succession Act applies, it is supreme. But there are certain areas that the Law of Succession Act will not apply, those 10 counties under Schedule 10. So when the court is faced with that lacunae, it is not really a lacunae. It will have to investigate what is the law of succession in those 10 counties. And for that manner, it will call evidence of that law. The evidence of law is provided by the elders and the community. It is not for the judge to tell them what their law is. But whenever the customs and the practices of that community fly in the face of morality or any other written law, for example, the Girl Mutilation Act and things like that, then the judge will have to make a decision whether to follow custom or to follow the law of succession. And to make that decision, it will have to be a judicious decision. It cannot be a decision that is just flying in the face of reality. Yeah. So
do we now say that the common law, that is the written law, is more superior than the customary laws that are under different traditional communities?
Under the Judicature Act, you go first through written law. Supreme law is the Constitution and treaties, international treaties and conventions. Then you come to case law. Then from case law is now when you get into custom. Custom sits at the bottom. And it is remembered because we are Africans, we are here as the legal profession to provide services of justice and law and order to a community. We are serving a community. We are not imposing law on a community, although there are certain aspects that, because of the Constitution, are imposed. For example, the provisions of the Constitution to do with equality between spouses, equality between the races, equality between the genders. So that's not something now you can ignore, because the Constitution has provided, and that is not how you flow. Custom is persuasive, but it is not binding until it's been accepted by a judicial determination by a court.
In a case where there's a written will, of course, that is more clear and more transparent, that who is supposed to inherit my properties, me, probably as a person who is deceased, of course, having a will. Now in this will, assuming it's a polygamous setup where a man perhaps has like 3 wives and then decides that in the will he includes only, let's say, 2 of his wives, and then omits the 3rd wife under circumstances that and then now it comes to the time of succession. The will is written. The 3rd wife, we say, is out of the will, but she was legally married to the deceased. Now, at this point, does she has the authority to claim succession as well, regardless of the written will by the deceased?
What we know is, under the Law of Succession Act, if it's applicable in that area, it's what Garissa, it's what Wajir and things like that, then you cannot do that. What is the general rule? The general testamentary freedom, where a man or a woman can be able to will away his goods to anyone, anywhere, and exclude people. That is the absolute testamentary freedom, mostly under English law. However, when they were passing the Law of Succession Act in the 70s and started applying in 1983, they made a provision that says, if a will excludes a dependent, the court may reread the will and insert reasonable provision for that person who has been left out. So you find the will is not absolute. If it has the mistake of having left out a spouse or a child or a dependent, the law of the Constitution says all children are equal, whether they are inside that marriage or they are born outside. Every spouse in that marriage is equal. There is no superior one or inferior one. Now, you have to come out and prove a customary law that says the first wife is entitled to this part of the property. You have to come out and prove the law that is affecting that type of distribution. However, if that law is impalatable, immoral, for example, then by having left a child or a spouse, then as far as you made the mistake of leaving the spouse out, the court will make a reasonable provision. The problem that has happened in our African history is that you find the father will leave everything to the sons and exclude the girls, the women. Now, when you look at that type of setup, the Supreme Court in Kenya has said you can't do that. Every child in there belongs, whether they are women or men, they're all equal. Let them divide the property equally. So you find the constitution has affected and it's a transformative constitution. It has affected our types of discriminations, our types of exclusions of women, girls, favoritism for one spouse and not the other, things like that. Now the problem now comes also when we have former spouses. Now in old African setup, because of the various ways the things have been happening, we used to have retired wives. That concept has not been known in English law. You cannot retire a wife, but in custom you can do retirement of a wife for various reasons and various setups. So when you were passing the Law Succession Act in the 70s and it came back, it came to in fact in 1983, former spouses had the right to inherit, because obviously there's nothing like a former spouse in African law. It is a retired wife. There was nothing like divorce that is perfected by a decree nisi and a decree absolute of divorce. We just had a retired wife, a retired spouse. Unfortunately for our country right now, we have passed an act that says a spouse is not a former spouse. It is the spouse as defined in the Marriage Act. Now the Marriage Act has various classes of marriage. And one of the most common is the African customary marriage. So that African customary marriage, you have to get a certificate of marriage using affidavits from the elders saying that they saw you getting married and you went through the ceremonies of marriage. So when you look at it that way, you're able to find now there is exclusion of assumed wives. Everybody has to have a marriage certificate. So when you're coming to claim anything in succession and you're saying you're a spouse, to this day you have to either produce a certificate of marriage or claim that you are a wife because of presumption, which is usually now something that Parliament wanted to totally avoid. So you'll have a greater problem trying to inherit if you don't have a marriage certificate. Yes.
So at that point is that even for the neglected wife from the will, as long as she has a marriage certificate and she's not included in the will, she's entitled to go ahead and seek succession from the court.
Yes, she has a right to challenge any grant of probate or any confirmation of grant if she has been excluded. That's her right. She'll come to court, prove she was a married woman and that she's entitled to equal treatment with the other spouses, the other wives. And for example, right now they have amended they are trying to amend the Law Succession Act to say even the man has the right to inherit from the woman. Previously it was very difficult because it was somewhat discriminatory, because it was assuming that the man will always die first and then the women and the children are left. But now they have amended it to provide equality between the genders and provided that instead of saying a dependent is a wives, former wives and children, now it says dependent is a spouse as defined under the Marriage Act. Yeah.
And now, just jumping in now into another contentious matter. Of course, succession surrounds the marriage setup, of course, when there is polygamy. And that is a discussion that we are going to have in our second part of succession law. But that is where we wind up this particular episode of Know Your Law. We have been talking on matters to do with succession. What surrounds the succession law is what we have been discussing. episode of this part of our discussion, we will talk about who is entitled to inherit under the new amendment law of the Kenyan Constitution in regards to succession. My name is Chris Sambo, and I've had my guest who is an advocate of the High Court of Kenya, Kevin Doho. Thank you so much for making time for this program.
You're welcome.
And see you on the next episode. Goodbye.